Hi, this is Michael Pariente here at the Pariente Law Firm PC in my conference room at the Howard Hughes Center, and I wanted to talk to you today about John Jones and his recent arrest. As you may know, he's a very prominent, famous UFC fighter who was recently arrested and charged with leaving the scene of an accident after having caused substantial bodily harm in New Mexico. In Nevada, that is a very serious offense as well. If you're charged with leaving the scene of an accident after having caused substantial bodily harm or death, that is a felony that if you're convicted of, you could get probation, but if you get time, you're looking at a minimum of 2 years up to 15 years of incarceration. If you're involved in a hit and run, or if you're involved in leaving the scene of an accident, and there's no substantial bodily harm. Now, what do we mean by substantial bodily harm? Was there a broken bone? Was there stitches involved? Those are considered substantial bodily harm under Nevada law. If there's no broken bones and there's no substantial bodily harm, then those cases are generally charged as misdemeanors. If you're in a situation where you are being investigated for leaving the scene of an accident, whether there was substantial bodily harm or death involved, or whether there was not substantial bodily harm nor death involved, give me a call. It's very important that you address this and don't just put your head in the sand. You will often be contacted by Las Vegas Metropolitan Police Department either by phone or the Vehicular Crimes Unit of Las Vegas Metropolitan Police Department will send you a letter. So if you get that letter or you get a call, it's best that you talk to an attorney first. If you're in that situation, you've received a letter or a call, you're being investigated for this type of crime, give me a call at my office at 702-966-5310. I'll be more than happy to meet with you. The first consultation is always free. If you're calling from out of state, we can talk over the phone and I can fully explain your rights to you and how I can help you. Hi, this is Mike Pariente here at the Pariente Law Firm PC in my conference room at the Howard Hughes Center. Wanted to talk about the big fight tomorrow, Mayweather-Pacquiao. If you're from Las Vegas or you're from out of state or if you're out of the country and you're going to the fight, it's really important that you understand one simple rule in Las Vegas, that what happens in Vegas can stay on your record. I'm talking about the most commonly charged offenses in Las Vegas for big events such as the fight are solicitation for prostitution, battery, such as simple battery, battery constituting domestic violence, battery of substantial bodily harm, theft, DUI, and of course possession of controlled substance like being caught with cocaine. If you're charged with any of those offenses, it's very important that you have a top-notch aggressive criminal defense lawyer fighting for you. In most cases, 9 out of 10 cases I would say, you won't have to come back to Las Vegas. I'll be able to go to all of your court appearances for you. So if you're in that situation where you've been cited for any of those offenses that I've mentioned or any other offenses such as the more minor charges like disorderly conduct or public intoxication, I can take care of those for you without you having to come back. So give me a call at 702-966-5310. I'd be more than happy to talk to you about what I can do for you. Hi, this is Michael Pariente. I am in the conference room here at the Pariente Law Firm PC at Howard Hughes Center. And I wanted to talk a little bit about the Dakar Sarnoff guilty verdict. Yesterday he was convicted on all 30 counts by a federal jury in Boston for his role in the Boston Marathon bombing in 2013. Now the question is, what happens here? Now that he's been convicted, he is still detained. In fact, he's been detained in jail. He's been in custody in jail since the beginning of 2013 when he was arrested. So at this point, he comes back to the jury for sentencing. It's the same jury that heard the initial case, and there are 12 jurors. What happens at this point is the prosecution is going to present aggravating factors to argue to the jury that he should receive the death penalty, and the defense will present what are called mitigating factors. Mitigating factors to try to convince just one juror that he should be spared the death penalty. If the defense convinces just one juror that they should sentence him to life without the possibility of parole, then what will happen is he will receive life without the possibility of parole, even if the other 11 jurors voted for death. At the federal level, What happens is when you are sentenced on a federal crime, you are sentenced by a judge. You're never sentenced by a jury. A jury does not impose punishment. However, this is in a capital case like this, it is the jury that determines your two options. And those are your only two options. The jury can't say we want to give him 50 years or we want to give him probation. The jury must make the decision of whether to give Mr. Sarnoff life without the possibility of parole or to give him a sentence of death. Now, the next step after that is for an appeal. He will likely file an appeal there's various ways he can do that. There's a statute, 28 U.S.C. 2255, that's what's called ineffective assistance of counsel. He would need to argue successfully that his trial court counsel made not just an error, but secondly, that the error that was made by his lawyers prejudiced his trial and did not result in him having a fair trial. In other words, that the error that they made was of such a magnitude that it would, that if they did make that mistake, the outcome would have been different, that he would have been found not guilty. Now, the reality is that's a really hard argument to make. In a case like this, where you have 260 people who were injured, and even though the defense decided not to to cross-examine any of the bombing victims, that was something that would be viewed as a tactic, a trial tactic, and it's likely that would not be enough to rise to the level of ineffective assistance of counsel warranting a new trial. But in any event, I just wanted to take a couple of minutes and tell you about the legal procedure from here on out now that he's been found guilty. And in the next couple of days and the next couple of weeks, I'll be doing a couple more broadcasts just to let you know what else is going to happen and also give you my analysis as an attorney. I look forward to having this conversation again with you very soon. Thank you.